back row. Thanks, Morgan, for the intro. As Morgan said, I am a Santa Clara grad. I went to USC for undergrad and then came here for law school. I actually had Wills and Trust in this room, so it's a little bit weird to be up here, and I think I had something else in this room, but I can't remember what. It's funny how that stuff just flies out of your mind. Anyway, thanks also for bringing the pizza. When I was in law school, we used to carry Ziploc bags with us everywhere so that we could steal from all the lunchtime presentations and eat later. So I don't know if that's still going on or if I just gave a whole new crop of students a new idea, but it was a good tip. It was a good tip. So yeah, I work at Wilson Sonsini, Goodrich & Rosati. I'm in the employment litigation group, which also focuses on trade secrets litigation. So my job is to represent primarily employers, usually we're primarily defense, in employment disputes. In the last couple years, I've kind of adopted and or been appointed the social media expert of our group. So I do presentations like this all over the place. Social media hasn't turned into a big litigation machine just yet. There are some social media cases, but as you know, the courts lag behind technology by quite a bit. So we're still waiting for it to catch up. So it's almost like we're betting that social media is going to be the next big thing. I mean, we hope so, right? Otherwise, I'll know all this information for no good. So anyway, today we're going to talk about employment implications for social media use, particularly as a job seeker. What do you need to do, and what is going to be happening with the job search? Once you're employed, what rights do you have as an employee, and also what the law says about how managers have to treat their employees. One thing that no one really talks about in law school is, as soon as you become a lawyer, you are a supervisor on day one. You have secretaries, you have paralegals, you have people in the mailroom who are depending on you to tell them what to do. And if you find something from one of your employees that's crazy, you are now responsible for handling it, right? So you're not only an employee of your firm or your organization, but you also are this manager, and we have to kind of adjust, okay? So I'm going to try to stay up here even though I like to move. Okay. How many of you use social networking for job search purposes? LinkedIn, referrals, posts on Facebook about anybody have an opening for a third grade teacher kind of thing, right? We all do. Social media, when we're talking about this presentation, is not just the big ones, the Facebooks, the Twitters, the LinkedIns. It's company-sponsored blogs, it's private blogs, it's Tumblr feeds, it's Unvarnished. If any of you have not gone to unvarnished.com, you should do it immediately because it is the most hilarious site you've ever seen. It's basically a website where people can complain about their bosses, and then they send an email to the boss, and if the boss doesn't respond, they have this little snarky like, we received no comment back about whether this is accurate information. So anyway, it's kind of a one-sided bias thing, but it's pretty funny. Okay, so here's something I like to start with. These are actual Twitter posts that employers have found, posted by their employees. This is what not to do, and what employers will see. So put yourself in the position of the supervisor for a second. One of your employees posts, late for work, still drunk, oh well. What do you do as the supervisor? Do you call that guy and say, stay the hell home, I don't want you here if you're drunk? Can you fire him for that? What about, just lied to my boss to leave work for a bit, me starving counts as a family emergency, right? What about that one? Amazing, right? That's what I was just telling Morgan. As long as employees are stupid, I have a job. Because these are the people who call me, oh my God, we found this, what do we do? My retard boss said he put in for raises. I think he lies. He's known for that. His daddy owns the company. Daddy found this post and sent it to me. So, not good, right? So these are the kind of things that we're supposed to be thinking about. Obviously, you wouldn't think that you would be dumb enough to put this stuff up there, but trust me, it happens every single day. Okay, a couple little quick facts. Facebook has 845 million members. 45% of people in North America regularly log on. Mobile Facebook is increasing dramatically in terms of usage. I don't know if you guys heard Zuckerberg's speech to the shareholders this year, and he said, mobile is where it's at, and we're going to improve it, and we're going to get it together, right? So that's kind of where it's going. All this use points to the fact that some of it is happening at work, right? Obviously, you guys are probably on Facebook all the time while you're in class, so when you have a job, it's exactly the same, except you have less time. So it's going to be, a lot of this use is happening in the workplace, and that's where I come in. So just another little quick poll. A new study shows Gen Yers, which is all of us, consider access to social media and mobile devices of equal or greater importance than salary. What do you think about that? I think no way. For me, I'd rather have my high salary and not have my iPhone, because that's my leash. But I mean, I think it's important, right? It's interesting to see how this changes. And if you know people, my niece is 17 and she just cannot live without her Facebook, you know? So it's changing as we go, and this is the kind of everyone's doing it kind of norm. So let's get into when you're looking for a job. I should keep my eye on the time here. When you're looking for a job, informal background checks is what usually gets employers in trouble when it comes to applicants. And here's what I mean by that. When you're doing an actual background check on an applicant, you're required to provide the applicant with specific information, an authorization sheet, and get their signature. And then as the applicant, you're entitled to a copy of the background check report, right? Anybody who's had any kind of a job probably has seen this. If you haven't, you will soon. It's a couple pages, and then you sign at the bottom, you get a copy of it at the end. Informal background checks, which is what I'm calling when HR manager goes, I'm going to see what the heck's going on this guy's Facebook. Those don't require that authorization, so you don't know when they're doing it. And you won't be able to tell if they're hiring you because of what they find or not, okay? Publicly available information is searchable without a penalty, for now, I would like to say. I have seen in the last 2 years, every time there's a Congress in session or legislatures walking around, there seems to be continually introduction of new bills and laws related to social media because they're all trying to catch up, right? So for now, this is available to employers without a penalty. We'll wait and see what happens with that. But only publicly available information. You might all remember a couple months ago, there was this big news thing about employers asking for Facebook passwords at interviews. You can't do that. Maryland has a law prohibiting that, California's is pending, and 8 other states have similar laws. So the private information in your private settings can be found, but public information can be. And you would be surprised how many people do not understand Facebook privacy settings. And if you go on Facebook, you can find a lot of stuff. Here's a good one. A study of 300 hiring managers found that 90% looked at social media on their job applicants. And of those people, 69% did not hire someone based on what they found. And mostly what they were finding was alcohol and drug use. That picture of you guzzling from a tequila bottle or taking a bong hit, employers don't like that stuff. Discriminatory comments. I just had a phone call the other day from an employer who told me they had an applicant post, I'll paraphrase, but generally, Barack Obama only got elected because he's black, and all the black people voted for them because they're racist against white people. Generally, right? He doesn't want to hire this guy. I think he's discriminatory at least, right? Potentially racist. I don't think he's a fit for my organization. That's the amorphous fit argument we always get, right? For some reason, we don't want this guy. So that's 69% of these people finding this. They also are looking at bad statements or unprofessional statements about your former boss and your former work, because they don't want to be next, right? They tell you that during interviews, right? Don't ever say I'm leaving that job because my boss sucks. Make something else up even if your boss sucks. But it's important to know that 68% of hiring managers hired because there was an online presence. So it's almost an equal number. So what does that tell us? That tells us you can't just avoid the whole issue and say like, all right, I'm going in for on-campus interviews, I'm taking off my Facebook page. Because now it looks really fishy, right? In the age of information, we want all our information, we want to know what's going on with people, and having no online presence looks really, really fishy. Almost like you're a felon or something, right? Like, why don't you have a Facebook page? Everyone has a Facebook page. My 9-year-old niece has a Facebook page. Okay. Stretching the truth. We all do it, right? Just a little stretch, just to make myself look a little bit more important on that last project that I worked on. Or fill in a blank patch in my resume. I wasn't unemployed for 6 months. I was off exploring Singapore, right? We all do these kind of things. Job seekers are using LinkedIn for resume building, for references, for networking. And stretching on LinkedIn is a problem. Primarily because if you stretch on a resume, the only person who's going to see it on your resume or your cover letter is the employer. If you stretch on LinkedIn, your entire network sees it. And now you have diminished your credibility to potentially hundreds of people, right? By the way, I would like to say that I use this picture without copyright permission, so there's that. Lies can be easily discovered. I interviewed a woman this morning who wants to summer at Wilson for her 2L summer next year. And her summer at the DA's office, man, I think she might have been trying capital crimes listening to her talk, right? So I was a 1L. I had a summer job at, the public defender's office, and I had summer internships, and I am pretty sure that she didn't do half the stuff she said on her resume. And I try to give her a chance to explain herself in the interview, and she stuck to her story. So what does that say to me as a hiring person? I'm on Wilson's hiring committee, so I have to interview people all the time. That says to me, you're untrustworthy, and guess what? We got a line of people out the door who want this job. So if I think something's fishy with you, then I'm just not gonna waste my time. Okay? Employers can also do searches absent an interview, right? So there's a couple techniques here that we've seen. How many CFOs does one company have at any given time? They might know somebody who knew the CFO at the time when you're claiming you were the CFO, right? It's always better to keep that stuff as close to the vest as possible. As I said, a cover letter or resume goes only to your company, but the networking is really a much broader impact. Studies are showing that people are more likely to lie about personal interests on social media than job-related interests for obvious reasons, right? We all know the big executives who claim they got a degree they never got, and so those things are in the news. So people are more likely to lie about personal interests, but again, that stuff can be discovered, very easily in an interview. And if you claim to be a skiing enthusiast and you're interviewing with someone who's a skiing enthusiast and you don't know the correct terms, it's going to look pretty awkward, right, at the interview. And again, your trustworthiness has just gone down. In the event that you blatantly lie about something that is job-related and then you get hired, you can be fired because the law will not protect you if you have fraudulently got a job based on something that's job-related, right? So if you come in telling me as a law firm, as a law student, that you have first chaired 6 depositions, and I throw you in there and you make a disaster out of it, and now I can't use that witness at trial, which actually happened to me last year, and I was sitting there like, this is going to be a mess. Like, I'm just envisioning what the transcript's going to look like. I can't use this guy. I've just wasted everybody's morning and all this money taking this deposition of somebody who now has to be tossed from the witnesses. We can't possibly use them, right? Because, as you all know from evidence, you can't ask questions in trial that you haven't asked during the deposition, right? So now the deposition's a mess, and what am I going to do? So that can lead to some pretty significant discipline if it's job-related. Are there questions about that? Okay. LinkedIn, recommendations, everyone's favorite, right? Everyone's asking everyone for LinkedIn recommendations. Not so much now. I think 3-4 years ago it was a lot of LinkedIn activity, and now it's kind of settled into a groove somewhere. But there are, considerations. Employers will consider the source, and employers will make assessments about you based on the people you're recommending, okay? You can also check, it's very easy to check on LinkedIn what the recommendations are. And so if you're making the same recommendation all the time, that's easy to check too, right? And so then the recommendation becomes useless. You can say a lot by reading between the lines. There's no negative recommendations on LinkedIn, but if you're sneaky about it, you can really say something pretty negative about people. So, be cautious about that. And then my last point is the legal risk, the employer's perspective on this. If you used to work with someone and you no longer do, the company has likely policies about what references can be made and what recommendations. Usually the company policy is that all work references or recommendations have to go through the legal department or through HR because there's specific criteria that has to be said. And also there's a lot of potential pitfalls here for recommendations in terms of defamation, fraudulent statements, etc., right? So the employer might have a policy, and if you're recommending former employees, you could be in violation of your firm's policy, and that's a whole other can of worms, okay? So my recommendation on LinkedIn recommendations is just be very careful. If you're asked to give a recommendation, make sure that you're not saying the same thing to every person, that you're not giving dishonest feedback, because it will look bad on you if it turns out that they hire someone based on your recommendation and then they're a total ditz, right? And also be cautious about these things when you're asking for recommendations, okay? how useful is it really? I mean, I've never asked for a LinkedIn recommendation from anyone because, quite frankly, I think they're worthless, but that's just my opinion. Okay, now you've been hired. Do you have a right to privacy? And, more importantly, when your supervisors in a couple months to a couple years, whenever you graduate from here, do your employees have a right to privacy? And what does the right to privacy look like? So we're going to get a little academic, but hopefully that's not a problem when we're in a school setting. Employers need to be careful about social media because it can impact rights of privacy. As we all undoubtedly know, to make a viable privacy claim, the employee must claim that they have a reasonable expectation of privacy, that privacy was intruded on, and the intrusion is unwarranted and highly offensive. Usually employers can wiggle out of privacy claims by that last point, right? There are a lot of cases where courts will say, yeah, they totally had a reasonable expectation of privacy and you totally violated it. But there was a legitimate business necessity for doing it, so you're good. You're off the hook. The most famous case of this that I like to say was a 2009 case called Hernandez versus Hillsides. And Hillsides was a home and school for learning disabled children. And so they lived there. There was a dorm. And the school became aware that one of the computers was accessing child pornography in their dorm, where these children all live. So they identified which computer it was. It was in an office that was shared by two women. The office had a door. The door had a lock. The women had used the office in the past to change for after-work workouts and stuff like that, right? So the reasonable expectation of privacy in their office was pretty clear. They expected that place to be private. The workplace put a video camera in there, a hidden video camera, to catch whoever was accessing the child porn. It didn't have sound. It only recorded at night because they found the access was happening only overnight. They never caught anybody. The videotape never videotaped anything. It didn't videotape the women changing. It didn't videotape anybody accessing the computer. The whole thing was a bust. But when the women discovered the camera, you better believe they brought a lawsuit about that, right? Why is there a video camera in my office? I change in here, okay? Reasonable expectation of privacy, totally violated, warranted. No legal problem, okay? And the court says, given that this is a home for children, it is supremely important that the company be able to detect who is accessing child pornography on their computer. We didn't say it was one of those two women. We just know it was from this computer. Could be anybody coming in there at night, right? So that's kind of the biggest privacy case. Now that doesn't include social media cases. And the question that we get a lot in our practice is email. What about employee email? Can we monitor their email? Can we read it? Does it matter if it's work email, rstewart@wsgro.com versus my Yahoo account? If I'm accessing my Yahoo account on my work computer, I should be able to get that information, right? So the other thing that's important about this, which we're going to talk about, is the blurring the line effect that's happening with our kind of current system, right? And particularly with lawyers. And by that I mean, am I ever off duty? Is there ever a minute where you could say, oh, she's not working right now? I would argue, probably not. I have my phone all the time. I have a 15-minute rule on answering emails. It doesn't matter if that email comes in at 2 o'clock in the morning, 5 in the morning, 6 in the evening. I have to answer those emails. When a merger's closing, we're up all night, 3 days in a row, whatever the case may be. So when am I off duty, right? So that's the line blurring thing that's happening, is that it's easy for employers to say, this is what you can do in the workplace, and this is what you can do at home. But as our technology merges the two, it becomes a little bit more difficult to assess. Okay? Kwan was the very first big Supreme Court privacy case about this, so I think it deserves a little bit of time. Kwan is a 2010 U.S. Supreme Court case. I actually flew out to D.C. for the arguments because we were all waiting with bated breath for this case, right? This is going to give us the definitive answer. And of course it didn't. But let me tell you the facts of the case because it's a little bit interesting. So Kwan was the sergeant on a SWAT team back in the early 2000s. I mean, it took until 2010 to get to the U.S. Supreme Court, but you know how those things go. They're pretty slow. So they had these two-way pagers for their SWAT team. I know, dates the case, right? So they had these two-way pagers where they would let the SWAT team members know where the emergency is, where they have to be, when they're on call, etc. Right? They had a company policy, as every company has, you will shortly see, that says you have no expectation of privacy in your company equipment. But the pagers were not part of the policy because the policy was written before the pagers came out. Okay? So pagers not covered by the policy. Then there may or may not have been a staff meeting where the policy was extended to the pagers, but evidence is questionable on that point, right? Then one of the managers said, we don't care what you do with your pagers. So there's all this back and forth. Like, is there an expectation of privacy? Is there not an expectation of privacy? What's going on with the pagers? Okay, so Quan is a very busy man, and he is carrying on no less than 3 extramarital affairs, primarily by using his two-way pager with these women who are not his wife. So the company's unofficial rule was, we have data plans, and you have X number of pages per month. If you go over that pages number, then you pay us for the overages, and we don't care what the pages say. So Quan is writing these checks every month because he's significantly going over. It takes a lot of time to carry on that many affairs. So he's writing the checks, and he's paying for it, and everything's all copacetic. And so one day, they get a little bit suspicious. Like, why is he going over his plans so much? And the company says their real concern was, maybe we need to up our data plan limit, right? Maybe it's unfair to ask these employees to pay all this money. If all of this is work-related, we might be on the wrong plan. Whether that's their actual reasoning or not for checking the pages, we'll never know. So they checked the pages. They did an audit. And they got all pages and pages and pages of his sexually explicit text messages, and they disciplined him significantly. So then he brought the lawsuit. I had a reasonable expectation of privacy in the pager. You looked at it without my permission, and now I'm suing you. So we all thought, this is going to be it. The Supreme Court is going to tell us if employees have an expectation of privacy in their company-provided equipment, right? This goes to my iPhone, it goes to my iPad, it goes to my laptop, it goes to everything that Wilson gives me. Do I have an expectation of privacy? So the Supreme Court ducks and dodges and says, we're not going to talk about it. We are going to assume he had an expectation of privacy for purposes of our analysis, but we don't make any assessment, one way or the other. Thanks a lot, people, for nothing, right? Like, I flew all the way to DC for this, and it was like nonsense. But in the end, it didn't matter. They found no invasion of privacy because the employer provided reason of, maybe we don't have enough text messages, data messaging on our plan, was adequate for their violation. So even with the assumed privacy right, they said no violation, okay? But that was a governmental employer, right? That was a city police station. So what about private employers? I mean, most of us are going to deal with private employers in our practice. We got a little bit of guidance in early 2011 from the California court in Holmes v. Petrovich. Holmes was a pregnant employee who was exchanging emails with her supervisor about going out on leave, and then left, quit the job. She had also been exchanging emails with her attorney about suing the company through her company email account, okay? So when she left, the company got them and used them against her. You weren't ever intending to go out on leave, you were going to sue us from the start, blah, 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 right? The court not only said they could use the emails, they eliminated the attorney-client privilege protection on those emails. They said, which is very unusual for a California court. California courts will uphold attorney-client privilege in almost every case. But they said it's equivalent to speaking to her attorney on a speakerphone in a conference room with the doors open for everyone to hear. She has waived the privilege by using her work email account, okay? They also said it's the difference between a postcard and a sealed letter, and they had a bunch of other little metaphors and similes in there. I don't know what was going on with the clerks the day they wrote that opinion, but it's an interesting one if you want to check it out. Contrast that with the Steingart case, which was in New Jersey, so it's a little bit different. But the Steingart case was a woman who was using her personal email account, her Yahoo email account, from her work computer. But Yahoo caches the emails, right? So you can always go in, I mean, not me, because if I'm in the same room with a computer, it'll probably fry up and die, but somebody who's more technologically savvy than me can go into your computer and extract that yahoo.com or gmail.com information, right? And the court said there, that is potentially a reasonable expectation of privacy. She had a password, she didn't expect that the company would be looking at that, but this is New Jersey, right? And it was in 2009, so we're kind of waiting to see if that comes up again. My assumption, to tell you the truth, is that if it's on the company computer, it's fair game. And especially, when you log on to Facebook or when you log on to your Gmail, and there's that little box that says keep me checked in or keep me whatever it is. If you check that box and then you don't have to continue to enter your password, my guess is that's going to rule against you every time because now you've allowed that computer access, unfettered access to your email inbox. Okay? California also has A constitutional right to privacy, which you all know probably better than me, because I don't deal with this very much in my practice. But does it apply to social media? I think yes, it does. Remember, the information must not be publicly available to constitute an intrusion. So in the first place, we have that, right? Publicly available information doesn't count. Intrusion upon seclusion is intrusion into your private affairs or solitude. So if your manager is getting mixed up with your family, whatever you're posting on Facebook, there's a possibility there. Public disclosure, employer publicly discloses facts about the employee of an embarrassing nature. Often we'll have managers post about employee misbehavior or internal investigations. Even without posting names, people can figure it out pretty quick. So I supervise my secretary, 2 paralegals, and those are pretty much my direct reports. I kind of, on the side, supervise all the junior associates, right? But I wouldn't say I'm their boss necessarily. I don't write reviews for them or anything. So if I'm saying one of my subordinates is having a sexual harassment investigation, it's taking me all this time, right? Like, or something else equally stupid to put on Facebook. Somebody could pretty easily tell which of the 3 people I supervise that involves, right? Which person is getting questions asked about them. So then you could potentially have an obligation here, even if you haven't named any names. False light, statements by managers like, oh my gosh, this girl is late again, she sucks, right? If you're not late again, that could be false light. Appropriation is the least likely of these to happen, which is using somebody's likeness to promote your product. Usually people like that. The only place I've seen this come up is when somebody leaves and their picture is still on the company website or something like that, right? Other questions so far? Okay. Real quick on external websites, the Stored Communications Act is a federal act that is incredibly difficult and impossible to understand. But basically it prohibits unauthorized access to stored communications. Stored in the meaning of the act was written a long enough time ago that it doesn't incorporate almost anything that we use in our modern life today. It actually talks about, recording people's voices on an actual handheld recorder and stuff like that. So its usefulness is limited. However, it is a law, and so we do have to follow it. Stored communications a lot of times can be, like the Yahoo cache. In the Quan case with the SWAT officer, in order to get the pages, the printout of all the pages that Quan was doing with his many mistresses, they had to call the cell phone provider and get that stuff downloaded from them, right? So then the cell phone provider got this stored information from somewhere. So that's how it pulls in, right? Social media, Stored Communications Act was expanded to the social media context in California in May 2010. A California court said non-public information can be stored communications. So if you have unauthorized access to it as an employer, that's bad, and that's a violation of the law. So in other words, if I am asking you for your Facebook password and then getting into your private stuff that I can't see publicly, that could be a violation of this, okay? As well as the other laws. So a couple cases to illustrate that. Pietriello, which was a New Jersey case, and Knopf, which is a much older case in terms of social media. These were both blogs that, in both cases, blogs were started by employees, which were very critical of management. They were both password-protected blogs, passwords only available to the employees and not the managers, right? We're talking about them. We don't want them to see it. And Pietriello was a restaurant chain, and they had some pretty awful stuff on there about their managers. Anybody who's ever worked in a restaurant knows how waiters talk and bartenders, right? I was a waitress for many, many years. Maybe one day when I retire from the law, I'll go back to it. It was lots of fun. So anyway, it can get pretty nasty. So in both cases, the managers got the password from somebody and checked and fired people, right? You are saying all kind of crap about me. You're out of here. In the Pietriello case, the court said this is a violation of the Stored Communications Act because you coerced that access from someone. Your access was unauthorized, okay? And in the Knopf case, very similar, but slightly different result. This is coming up a lot more in our trade secrets practice because trade secret theft is an increasing source of litigation. It's probably the biggest source of litigation besides class actions that I do in my daily practice now. And one of the things about unauthorized access to websites is, where does the access end? If I fire my CEO on Monday and he accesses the trade secrets on Tuesday, does he have unauthorized access to that information? In addition to the trade secret theft, can I get him for an SCA claim? So it's just another cause of action. We like to throw as many at the wall and see what sticks. We also get a lot of cases about, for example, employee is claiming they're out on disability leave for their back. This is one I had last year. That was one of my favorites to investigate. It was so much fun. Employee claims that his back is so messed up, he can't even sit in the chair the whole day. He can't even sit in the chair for 3 hours. Even with the stand-up desk and everything else, he is wasted, right? He has got to be under constant medical care. And then on his Facebook page, guess where employee is for last week? At Burning Man, dancing and sleeping on the ground and staying up all night drinking. And what do? Can we do something about that guy?
If someone with back problems standing is laying on the ground, it's better than sitting. Infinitely better than
Yeah, agreed. I had to look up everything about back problems.
Sure.
Trust me, I know all about it now. But it was really funny because you get this call, I'm an employment lawyer, and everything in employment law as compared to transactional corporate law or securities where things have a very lengthened time frame, everything in employment law is an emergency, right? Every time my phone rings, it's like, we have this massive problem, we need to fix it now, right? So my whole life is like one fire drill after another, which is why I talk so fast. I think I just got to get stuff taken care of. So yeah, it was interesting. You never know what's going to happen. When you pick up the phone, you don't expect to hear, this MFer is out and he's got a back problem and now he's at Burning Man. I just know he's doing drugs there. And you're like, oh my gosh, like how is this job related, And the ironic thing is if he'd have just taken vacation time, nobody would have even cared. Okay, so bottom line on privacy, we still don't really know. Do you have an expectation of privacy in your employer-provided devices? Who knows? I think in California, it's pretty clear. Employer-provided email is no privacy. Employer-provided equipment, probably no privacy. But keep in mind that blurring the line, right? So if I have my iPhone, which I do, WSGR gives me that iPhone. They pay for my iPhone. They own my phone number. If I ever leave, they get my phone and my phone number back, right? They pay for it every month because they have to do it. Same with my iPad, same with my laptop, right? And this is not unusual. I think everybody in the Silicon Valley would do that. Mostly, I would say. So on my iPhone, I have my work emails, but I also have my Yahoo emails, and I also have my Gmail emails, right? And I get personal calls on that phone. That's my phone. If somebody asks me for my phone number, that's the phone number I'm going to give them, So how does that work in terms of that blurred line? That's company-provided equipment. If they can look at everything on there, that seems to me like a violation of my privacy, right? If they can look at my Yahoo emails, my cell phone, my, if the doctor's leaving me text messages or whatever. But it's company-provided equipment. So the bottom line is, all of that, we really don't know the answer. We're waiting to see. It's always safest to err on the side of caution. So when it comes to social media, top-level concerns for the employer. Harassment liability, discrimination liability, defamation, disparagement, trade secret exposure. These are the big ones. Manager statements on social media are often imputed to the company. A manager, as you all know, the apparent authority kind of thing, right? A manager is considered the company for purposes of the law. Also, you can expose trade secrets of the company or strategic decisions without intending to if you are set apart as an employee of that company, right? So if I work at Startup A, and it's on my Facebook page, I work at Startup A, and then I post something like, big news coming out this week, I'm about to be rich. Does that key someone off that maybe my company is about to be bought? Maybe, right? So now, am I in trouble? Potentially. If that was supposed to be confidential information, the company could be really mad. I actually had a merger not too long ago. I don't want this to turn into the Rebecca Stewart show, but I think the anecdotes are interesting. Tell me if you want me to knock it off, and I'll just stick to the slides. I had a merger not too long ago where there were only 15 employees of the being bought company. And they were being bought by American Express, which is a giant company. And these 15 employees, within a day, all of them decided to like American Express. So they all had these, this person now likes American Express, this person now likes American Express, all over their Facebook. And they were all like, American Express is awesome, because they knew about the merger. And then we're getting calls like, what do we do? Like, how do we shut this down? obviously in that circumstance, we represented American Express, and they were like, dude, you're letting the cat out of the bag. Like, we have the press release all set, we're ready to go with it, you can't just be telling people. They weren't telling people about the merger, but it might be inferred, right? So that's the kind of interesting stuff I get to deal with. Okay, employee concerns. Obviously privacy, which we talked about. Possible discipline for appropriate posts. If you're posting something related to whistleblowing, in other words, the company is fraudulently doing something with their finances or breaking some other big law, you shouldn't be punished for that. But it's a concern, right? Because if the employers aren't trained by someone like me, then they might punish you for that kind of thing, right? And say it's confidential information. Concerted activity, we're going to talk about in some detail. Those are employee concerns. Also employee concerns, discipline for inappropriate posts, okay? So, over the line complaints about management, people continue to surprise me by saying ridiculous things on Facebook that they shouldn't. People at my own firm, generally not the attorneys, although there have been some exceptions, will post stuff about how awful their boss is, he's a dick, he's an asshole, he's a whatever, and you're like, this is going to be seen by somebody. It doesn't take very much for us to take that to the management. Confidential information, obviously, and then off-duty conduct, like we talked about. So, off-duty conduct is protected if it's lawful. So if I'm a smoker, for example, and I'm smoking at home, they can't fire me for smoking at home, right? That's lawful conduct off-duty. If I'm a drinker and I'm drinking at home, they can't punish me for that either. But if I'm posting pictures of myself guzzling a tequila bottle, and then at 1 a.m., and then at 3 a.m., I'm on a phone call with China talking about a merger agreement, that starts to look job-related, right? Like, were you really drunk? And particularly if that merger goes south because of something that I said or didn't say, is that going to be related? So the off-duty conduct thing is really, I think, the next level of all of this social media, and we're going to have to figure out where the line is. Can you be disciplined for off-duty conduct? The answer is yes. But there has to be specific factors. No reasonable expectation of privacy. For instance, the public pages of Facebook, right? There has to be a nexus to your job performance and consistent enforcement of a company policy. The company cannot choose to discipline you if they haven't disciplined coworker B for the same type of thing, right? There has to be this consistent enforcement, otherwise there's discrimination cases. You can bring a discrimination case, that's a whole other presentation, but for any protected category. Religion, sex, military status, political affiliation, etc. So if, this woman is punished for Facebook conduct and I did the same Facebook conduct and I'm not, obviously she can't sue for gender discrimination because we're both women. But she can sue for something else, right? My national origin, my religion, etc. Okay? So let's look at some good off-duty conduct that I love. Police officer fired for selling an adult video showing him stripping out of his uniform. That firing was upheld because it was detrimental to the missions of the employer, which is, we're police officers, we are not porn stars. Okay? Flight attendant fired for posting revealing photographs of herself in her uniform. That case actually is interesting. She brought the lawsuit after she was fired for discrimination, saying that a man who posted revealing photographs of himself in his flight attendant uniform would not be similarly punished. So, it created this whole issue, right? Was there a man who posted revealing photos of himself in his flight attendant uniform? Can we see the photos? Like, what happened to these guys, right? This is like the workplace drama that feeds people. The case was against Delta Airlines, and then they went into bankruptcy, so the whole thing was stayed. So we never really got an outcome on that one. The North Carolina school teacher one is awesome. Under her hobbies and activities on her Facebook page, drinking and teaching chitlins in the ghetto. Fired. People do not like their child's teacher to be posting stuff like this, okay? And if you have a child, or if you have a niece or a nephew, right, and your kid's first or second grade teacher posts a picture of themselves at Halloween dressed as a sexy kitten, maybe you don't like that so much, right? So is it job related? Potentially. There has to be that nexus, okay? Finally, this is our final topic, NLRB. What's the NLRB? The NLRB is the National Labor Relations Board. If any of you have had what I would say is the misfortune to take administrative law, you may or may not know about the NLRB. The NLRB is a government agency that enacts the NLRA, which is the National Labor Relations Act. And what the act does is protects union activity, for the most part. So private employers, like all of my clients, don't care about it. They have been blissfully unaware of all the NLRA requirements because they don't have unions. So it protects union activity, preparation for union activity, union voting, all of the union-related issues, right? Informing a union, creating a union, keeping a union, everything. However, the NLRB has reached its little fingers into Silicon Valley with the social media stuff. And this is in the last 2 years. It never was around before that. Nobody even, these decisions started coming out and people were like, who's the NLRB? Like, it was really confusing to everyone. But here's what I think. The NLRB is dying. I think they are past their prime agency. And I think this is their last desperate attempt to stay relevant in today's society, is that they're making us listen to them on social media. In the meantime, they do have the floor, so we kind of got to listen. So the NLRA only protects protected concerted activity. So what is concerted activity? Concerted activity in a nutshell is 2 or more employees talking to each other, trying to improve the terms, working conditions, safety, wages, etc. of their employment. So if I'm saying to someone, it's the difference between I say to you, God, I hate my boss. That's nothing, right? That's just a gripe. Versus me saying to you, you know what? I don't think this equipment is safe, and I think someone's going to get hurt, and we should maybe go talk to management about it. That's concerted activity, right? So the NLRB has started saying social media posts could be concerted activity. As ridiculous as I post something, God, I hate my boss, and one of my coworkers hits the like button. Now we're engaged in concerted activity. It is the most ridiculous thing that any employer's lawyer has ever heard, because it doesn't make sense. That's not concerted activity. That's like anticipatory concerted activity, and it doesn't even relate to working conditions, right? But the NLRB has the floor, so we're listening. So anyway, there's a violation of the law if you don't protect that kind of concerted activity, if you discipline someone for it. So in October 2010, the AMR case came out, and this was the first time that the NLRB showed up in social media. And it was the perfect case for them to do it. And I just kind of think they were just waiting for this case to come along, you know, so they could like make their stance. The AMR is an ambulance company. Ambulance Tech was issued a customer complaint for her behavior. So she was told to write an incident report. They were unionized, enter NLRB, right? And so she asked for her union rep, and they said no. So she writes the incident report, she gets disciplined, the whole thing is a mess. She goes online and she calls her boss a dick, a scumbag, and a 17, which is company code for mentally ill person. I can't believe they have a 17 running this joint, right? Which sounds ridiculous. I mean, I always read these cases and I think, God, to be a fly on the wall in that deposition, you know? Like, what do you mean by, why they got this 17 running the place? I mean, to lawyers that sounds so foreign, but anyway, it's fine. So the NLRB came in and said, you denied her union representation, and you fired her for insubordination for calling her boss these names, and you can't do that. And you have to reinstate her to her position. And you have to give her all these back benefits. And so they eventually settled out of court. So, we didn't get a final resolution of what was going to happen with this case. But this was kind of the indication, the initial aha moment. NLRB is paying attention to social media, but we still thought it was just for unions, right? NLRB only deals with unions, and this was a union case. Then came along Hispanics United. Hispanics United is a social service agency. They're not the union workplace. So I'm going to read a little bit of the facts because it gets complicated. One employee was complaining, criticizing her co-worker's performance, right? Their work sucks, and clients aren't going to want to come here because all these people suck at doing their job. Okay? She also complained about workload issues, and then months later, she accused one of her coworkers of not properly assisting a client, and they got into this big Facebook battle, right? Where, they're calling each other names, and the other coworkers are jumping in with comments, and it was like this, totally ridiculous thing. So then the executive director says, we got to have a meeting to figure this out. You people are all over each other. We're going to meet and figure it out. So in preparation for the meeting with the executive director, the first employee posted on Facebook Facebook something like, I think I'm right, this chick never does her work right, and this whole place is going down the toilet. Who agrees with me? And then other employees started commenting, yeah, go girl, no, you're wrong, whatever, right? So then she had this list of comments. That's the concerted activity. Surprise! The NLRB says, since it was entered into in a discussion in preparation for taking a concern to management, because she said, I'm going to the executive director with this, then it can be concerted activity. It can be people, taking concerns to management as a group. So again, this is not the technical definition of concerted activity. This is more the definition of a personal gripe, right? Anybody who knows what concerted activity is, you can't just say, I hate my job, I'm going to go talk to my boss tomorrow, and someone hits the like button and now you're totally protected from termination. That doesn't make any sense. Employers are really up in arms about this. And then, finally, stage point. We have a little bit more information here. This one, the employee was kind of off the rails, and he was posting stuff on Facebook about, I hate this place, they're going to make me go postal, stuff that really makes their coworkers concerned, nobody wants to be in a place with someone who's saying that kind of stuff. He was saying his supervisor was having an affair with people, etc. So, other employee, coworker, employee X we'll call him, comes to management with a complaint. He says, this guy's harassing me because he said I'm the one having an affair with the supervisor. So employee A was complaining about his supervisor and saying she's having affairs with people and she's a bitch and all this stuff. And then employee B was like, he's talking about me. He thinks I'm the one having an affair with her and that's inappropriate. My wife's not going to like that very much. So anyway, they ended up firing the guy and he sued, right, under this new NLRB case law. And the NLRB said that's a personal gripe. There was no information about working conditions. You weren't concerned about wages. You were just complaining about, the way that your attitude was in the workplace, etc. So then this sparked a whole new slew of law for me to deal with on a daily basis about social media policies. What is preventable, what is protectable, and what can be done. And I have basically, I think, rewritten the social media, our standard form policy, who knows how many times. And I read social media policies from companies all the time, and things that you might think as a company would be innocuous, something like you can't use our logo without our permission, right? That's not going to be okay because it can violate the act, the NLRA, if someone is taking a picture of something because it's an unsafe working condition or because they want to pick it and it happens to have your logo in it. Now you've violated the law and you weren't even intending to. So this is kind of a sticky area. That's probably more than you even need to know about it, but that's where it's headed, and it's all pretty interesting stuff. And I think that's it, unless there are questions. Any questions? Any questions? Yeah.
So, not thinking about the union or anything, but like I said, our own stuff. So if we have the privacy settings all the way up, and we post something on our status, for example, is that considered public, or is that something that's considered a private message between me and my 300 friends that's protected?
Yeah. So the new thing is whether the access can be got at through a secondary means. So if I'm friends with one of your 300 friends, can I ask them to send that to me?
Yeah,
or is that unauthorized
if your
access?
friend likes it, then it comes up on her profile, unbeknownst to me.
Exactly. So I think the jury's out on that. My answer is if all your privacy settings are up and you've done everything you can to protect yourself, that should be a private message. It's at the very least a very good argument. I think the more friends you have, the less that is to be acceptable. If you're one of these radio DJs that has 5,000 friends, I mean, how private really is that stuff?
Okay.
Yeah.
Wondering about the practical implementation of like you having an iPhone and looking at your private email on that. Does it affect how you write personal emails or anything? Or?
It does. And I'll tell you this, since my job is social media, not my whole job, but a big part of it at this point in my career, I am on Facebook and Twitter and LinkedIn every single day for most of the day, and I never post anything. I'm reading, I'm like a spy on that thing, right? I'm paying attention to everybody else, but I almost never post anything because I don't want anything to come back to me. And I'm always worried that one time I post something about, here's me and my husband clinking glasses at dinner, and then that night some phone call I'm on goes south, I am petrified that that's going to come back to haunt me. So yeah, it does affect me. personally. And a lot of people who have the company cell phone will have a second cell phone and just carry around 2 cell phones because they don't even want there to be any interaction, which I consider a little bit ridiculous.
What
But
about like the email portion of it though, not the social media part?
yeah, you know, I don't have any compunction about my personal email. I don't feel like that's part of it because, you know, the only California case we have on email was the Holmes case, which was a company email case. So I think personal email is still protected. We still have that New Jersey court case from 2009 saying that. So, you know, until I hear otherwise, I'm not worried about my personal email. Although I'll tell you this, when I got my new Mac, they switched us all over to Macs like 3 years ago, and it has the little webcam thing built in, and I put a little piece of tape over it because I'm totally paranoid that they're watching me in my office. Yeah.
Just FYI, the mic or the headphone port on the side can't be turned off, so
Oh,
technically they can listen to all your
oh, good tip. I know nothing about technology, so I rely on you people that tell me that stuff. Anything else? Well, I'm going to stay up here, you know, until I get kicked out. So if you have questions, feel free to come up and say hi or whatever. And thanks, guys, for coming.
And we do have a few minutes, so